the second round. In the second round, it goes 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So that is round two. We'll start round two with Ms. Sahota.
Thank you, Mr. Chair. So I'd like to first go back to the September 17th meeting with the Prime Minister and the Clerk of the Privy Council. You mentioned that it was here where you had specifically asked the Prime Minister whether he was interfering, and his answer was that the decision was always yours. Is that correct?
That's not exactly what I said. I had raised the background about comments that were made by the Prime Minister and the clerk, and I know that has been what has been reported in the media, but that's not what was said. I asked the Prime Minister a direct question after having comments around elections and being the member of Papineau. Are you interfering with my role as the Attorney General, my decision? And I advised him strongly not to do that. So it was my direct question to the Prime Minister.
And he said the decision was always yours, correct?
He did not say that. He said, no. That's not what I'm doing.
Okay. But you did mention in your opening statement that throughout the whole time you were Attorney General, you did recognize that the decision was always yours.
I 100% understand my role as the Attorney General, and it is my decision and my decision alone whether or not to issue a directive.
Okay. So this September 17th meeting, you had asked for it earlier in September, and you said at that point you had gone on vacation. And did you receive this request for the meeting quite quickly?
I didn't say that I went on vacation. I was actually down in Australia for a Five Eyes meeting and happened to thankfully have a couple of days off.
Okay.
When another very important issue arose. And I, at that point, had requested directly to Jerry Butts via text message that I wanted to have a one-on-one meeting with the Prime Minister. That was in and around September the 6th.
Okay. And then on September 17th, you received the meeting after you came back into the country.
I got back into the country on September the 12th and was able to meet with the Prime Minister, yes, on September the 17th.
Okay. So the main purpose for this meeting, what was the main purpose of the meeting?
I am not at liberty to discuss that as meetings and discussions between the Prime Minister and myself, other than what's covered in the waiver with respect to SNC and deferred prosecution agreements is covered by Cabinet confidence.
When the Clerk of the Privy Council testified here before committee, he had mentioned that the main purpose of that meeting was the Indigenous rights framework and that SNC-Lavalin was a subject matter that was touched on briefly. Would you be able to say if that was correct or incorrect?
I will say that the Clerk of the Privy Council is at liberty to say whatever he wants. I have indicated that the meeting of September the 17th had to do with another extremely important matter, but that the Prime Minister raised the issue of SNC and deferred prosecution agreements at the outset of that meeting.
Okay. My next question is about the fact that you had mentioned the appropriateness or inappropriateness and where the line has kind of been drawn. You've indicated that when talking about jobs, the Prime Minister or the member from Papineau was completely in an appropriate space. But when you said he had spoken about the headquarters moving out of Montreal, that was inappropriate. Is that correct?
No, I didn't say that. I said that where, and I didn't say alarm bells, but where my alarm bells went off was when the Clerk of the Privy Council talked about the fact that there was a board meeting for SNC coming up on Thursday, September the 20th, that there was an election in Quebec, and then the Prime Minister interjected and said, I'm a member, or I'm an MP from Quebec, the member for Papineau. That is entirely political and entirely inappropriate, which gave rise to the question that I asked the Prime Minister.
You had mentioned, just in some of your answers to the questions, about him mentioning he's the member from Papineau, correct, that he was talking about the election, and then he had mentioned that if we don't find a solution, the company might move from Montreal. And I mean, in my view, when a company picks up and moves from a city or from a country, that means job losses. Is that not correct?
Well, that's your view. Of course, I was aware of the potential for job losses.
Okay. And that is a legitimate conversation for a prime minister to have.
Well, again, at the time, I didn't see it as being entirely inappropriate. Of course, ministers of the Crown can approach the Attorney General and raise public policy concerns about decisions that the Attorney General will make. Where it became inappropriate was the sustained discussions after I had made my decision and made my decision known.
On September 18th, I believe you.
But this will be your last question.
Okay, thank you. On September 19th, you had both met with the clerk and you had met with Minister Morneau in the House. In your discussion with Minister Morneau, I believe you had said that it's inappropriate and he should stop talking about it when he had talked about saving jobs. But in your discussion with the clerk on that same day, you had offered that if SNC-Lavalin were to send a letter to you expressing their concerns and their public interest arguments, you were open to looking at that letter. Is that correct?
That's not correct. I did.
It's here in your statement, opening statement.
If you allow me to answer, I can just clarify where that part wasn't correct. I had discussion with the clerk of the Privy Council, recognizing the conversation that I had just the day before had with the Prime Minister, where he asked for solutions, recognizing I had already made my decision. I had indicated to the clerk of the Privy Council that if SNC were to send a letter to me as the Attorney General expressing their concerns, their national interest concerns, their public interest concerns, that if I were to have received a letter, I would have immediately forwarded it on to the Director of Public Prosecutions. I would not have looked at it because it is entirely within the purview of the Director of Public Prosecutions, and any involvement I would have in that letter would be inappropriate. So what I said was I would immediately forward it on to the Director, not consider the letter.
Okay, thank you.
Thank you. Ms. Raitt.
Ms. Wilson-Raybould, when you speak to Jerry Butts or Katie Telford or the clerk of the Privy Council, do you believe that they are speaking with the full authority of the Prime Minister in their discussions with you?
Yes.
I'm wondering some specific questions, if I may. Do you believe that the Prime Minister or anyone in the Prime Minister's office had any lawful authority to tell you to direct the Director of Public Prosecution on what to do?
No, I was the final, and as the Attorney General, is the final decision maker on whether or not, as the top prosecutor, to do anything with respect to a specific prosecution.
Yeah. Is it fair to say that, given your testimony and everything you've told us, that you suffered from repeated communications with you, either directly or indirectly, with the intent of changing your mind? It was repeated communications, directly or indirectly.
That's fair to say.
Okay. I'm wondering as well, given the number of times in the final part of your statement, Mr. Butts indicated to you in your conversation that you needed to find a solution to the issue. The clerk of the Privy Council, in the statement that you received, in the text that you received from your chief of staff, there's details about not wanting to debate legalities anymore. There's no solution that doesn't come from some interference. The clerk indicating that I think he, meaning the Prime Minister, is going to find a way to get it done one way or the other. You reference as well that it's the Prime Minister's prerogative to do what he wants. You said you were having thoughts of the Saturday Night Massacre. The clerk said he was worried about a collision between you and the Prime Minister. You mentioned a few minutes ago that you thought they were veiled threats. This all seems to me, if I may, that there was an intention from all of these comments and this continued pressure to make you fear for your job at the end of the day, that there would be a shuffle or that you would be removed from your position. Is that a fair assumption that I'm making?
Well, I'm not going to speak to the intention of other individuals.
Fair enough.
I will speak to the very heightened level of anxiety that I had that increased and culminated in my discussion with the clerk on December the 19th. And I remember distinctly ending that conversation with the clerk by saying, I am waiting for the other shoe to drop, which I believe that reflection or my comments can speak for themselves.
And I'm not trying to split a hair here, and I apologize if you take it that way and you can give me the same answer as you did on intention. But do you think the purpose of those comments were to cause you to have a second look at the issue because you were worried about whether or not you'd remain in cabinet?
Can you answer the question again?
I certainly can. Do you think the purpose of those comments that were thrown into your conversations, either with you, with your chief of staff, directly with the clerk, through Jerry Butts, through Katie Telford, or even the clerk indicating how anxious the Prime Minister was and you didn't want to be at loggerheads, do you think the purpose of those comments that they threw in their conversations was to put pressure on you and make you think about whether or not you would be remaining in cabinet?
I am confident that the purpose of those discussions, the December 18th and the December 19th discussions, were to put extraordinary pressure on me to change my mind.
Yeah.
As to the intention of the individuals that spoke to either my chief of staff or myself, I can't reflect on their intent.
Yeah, no, fair enough. I have. Okay. If I may, on January 7, you received your phone call that you were going to be moved in positions. I've had that phone call in the past as well, so I know what it's like. But I'm wondering if there was any conversation that you can tell us about in terms of who told you that you were going to be moved from Attorney General to Veterans Affairs, and if there's anything pertinent to SNC in that conversation.
Well, I did state, and this is within the order in council and the waiver that was provided me with respect to cabinet confidence, with respect to SNC and deferred prosecution agreements. I had a conversation with the Prime Minister on January the 7th, and he spoke to me about my being shuffled out as Minister of Justice and Attorney General, provided rationale of which I won't get into. And then I said to him, I can't help but think that this has something to do with a decision I would not take. I had a subsequent, very close in time conversation with Jerry Butts where I specifically said, I know this has to do with SNC and a decision that I wouldn't take. To which he said, are you questioning the integrity of the Prime Minister? To which I didn't say anything.
Thank you.
Thank you very much. We will now go to Mr. Assassi.
Thank you, Mr. Chair. Thank you, Ms. Wilson-Raybould. Good to see you here before committee today. Now, I won't be delving into facts. I will be talking about context, if you will. Now, you recall that in your capacity as Minister of Justice and Attorney General, that remediation agreements were considered and approved by Cabinet. Is that correct?
That is correct.
And you were also a Minister of Justice and Attorney General on June 6th when Parliament voted in favour of Bill C-74, and you yourself voted in favour of Bill C-74. Thank you. Now, you would agree with me that the concept of alternatives to prosecution is not a novel concept in the landscape of various areas of law. For example, in the area of international law, there are guidelines, going back to the 1990s about alternatives to prosecution. We see this quite often when it comes to our own criminal code, when it comes to diverting cases through the Youth Criminal Justice Act. We see it with respect to white-collar crime. Would you agree that it's that this concept has been around for quite some time?
I will say this. We now have in our criminal code tools that are provided to the prosecutors on whether or not to enter into negotiations around deferred prosecution agreements. These are tools that other countries have utilized.
Speaking of other countries, as you noted, and you did reference the Five Eyes, to the best of my understanding, with the exception of New Zealand, the United States has had deferred prosecutions. The United Kingdom has had it. France has a DPA-like mechanism. Australia is in the process of adopting it. So given all these developments, would it be fair to say that many commentators are of the view that we are now leveling the playing field and that we are playing catch-up with those jurisdictions?
Well, I'm not going to comment on what other commentators are saying, and I will say this. I am not going to make further comments on deferred prosecution agreements. I recognize my responsibilities as a member of Parliament, and I recognize that there are two court cases that are currently in play.
So perhaps I understand you don't want to speak to that issue, but you would agree that there were extensive public consultations on the issue.
There were consultations that were conducted in advance of the passage of the legislation.
Yes. Now, I understand in your remarks, you were suggesting that some people were approaching you and asking that you obtain legal counsel. Would it be fair to say, as a routine matter of work, that your department does receive legal advice from various firms?
I'm sorry, could you clarify what
Yes.
you meant by people were approaching me to obtain legal counsel in what context?
Yes, I understand that you referred that there was one discussion with Mr. Bouchard, and he asked you whether you would consider the option of seeking an external legal opinion.
So in the context of deferred prosecution agreements and SNC, yes, I had that conversation with Mathieu Bouchard, Elder Marquez, and a number of other individuals. At that time, all of those individuals knew that I was firm on my decision not to interfere with the discretion of the Director of Public Prosecutions, and having conversations about hiring external legal counsels in that environment is entirely inappropriate.
But you've worked on some very difficult files during the period you were serving as Minister of Justice and Attorney General. Would it be fair to say that routinely you would ask for outside counsel just to have a better understanding of various pieces of legislation?
In my role as the Minister of Justice, and having had the opportunity, as people here know, coming before this committee on various pieces of legislation, we would engage with external counsel. But let me be clear. My role as the Minister of Justice, shepherding legislation through the House of Commons, is entirely separate from my role as the Attorney General. Where suggestions of obtaining external legal counsel after I had made my decision as the Attorney General on this matter, that was entirely inappropriate.
Thank you very much. Last question, Mr. Assassi.
Thank you. Now, before I leave this section, would you mind explaining to us what your misgivings were about DPAs?
I do mind. I'm not going to have that conversation. I think it's inappropriate as a member of Parliament, recognizing that there are two matters before the court.
Thank you very much. Monsieur Paulus?
Merci.
Mr. Paulus, thank you. Thank you, Ms. Wilson-Raybould, for this very important testimony for Canada and for democracy. Before I begin, I just wanted to give Ms. Raitt a few moments.
Ms. Wilson-Raybould, first of all, having heard it all, I have to ask you the question. Going from being your first appointment and going through the last 4 months, and although having comfort going into Veterans Affairs, which is a wonderful portfolio, and I agree with you fully that you served there. How did you feel at the end of this? Like, what's the emotion that you felt out of all of it? I mean, you're giving us wonderful facts, but surely there must be some level of disappointment or sadness out of how everything has unfurled.
Generally, or with respect to being moved as minister?
No, in general, how you've been treated.
I have serious concerns about how things are reported. I have concerns about what people generally call smear campaigns. It makes me very sad when, and this isn't about me personally, it's about the work that I was able to do with an extraordinary group of people when I was the Minister of Justice and the Attorney General, being impugned publicly, recognizing the commitment that my public servants then, and I know to this day, have to ensuring justice in the country and moving forward with legislation, as well as my political staff. So how do I feel? How did I feel? I have to say that I loved being the Minister of Justice and the Attorney General. I can't imagine any lawyer not loving being the Minister of Justice and the Attorney General. And I believe that I served in that role with hard work and with integrity. And I'm proud of the legacy that we left. So I don't want to make anybody think that I wasn't sad when I was shuffled out of that role. Of course I was. But I understand that it's the prerogative of the Prime Minister to make those shuffles. And how I conduct myself is to embrace other opportunities, which I sought to do in the unfortunate limited time that I was the Minister of Veterans Affairs.
Thank you. And my colleague, Pierre Paulus.
Merci. Oui, merci.
Thank you, Mr. Chairman. Ms. Wilson-Raybould, the Minister of National Revenue, Ms. Laboutier, mentioned that this question was raised during a cabinet meeting. In his testimony, Mr. Wernick said it's never been discussed in cabinet. You can't have two different versions. I don't want the details. I just want to know which of these two people is right, Ms. Laboutier or Mr. Wernick.
Well, I'm not going to comment on which of those two people were right, but what I can tell you is what I know, recognizing that I'm able to speak about SNC and deferred prosecution agreements. We had discussions at Cabinet about creating a new tool for prosecutors, remediation agreements. There were conversations, but not central to the conversations. There were peripheral comments about SNC, but it was not the heart of our discussions. Our discussions were about creating the tool for prosecutors.
Okay, merci. Le Premier ministre Trudeau a dit.
Prime Minister Trudeau said that you could talk about information that's relevant on this affair. Do you think there is relevant information that you cannot discuss with us?
I answered a similar question to this one. As I said in the letter and as I said here today, and recognizing some of the questions that members around the table have asked, I have an inability to speak about the time frame between January the 14th when I was sworn in through to meetings that I may or may not have had with the Prime Minister, my resignation, and the conversations that obviously has been widely publicized that I had with my former colleagues around the cabinet table. I am not able to speak to those issues.
Thank you. Merci beaucoup. Mr. Rankin, this is the 3-minute time for you.
On February 12th, Madam Wilson-Raybould, the Prime Minister said this, quote, "If anyone felt differently, they had an obligation to raise that with me. No one, including yourself, did that," close quote. But you've testified that you met the Prime Minister on September 17th. You've testified that on December the 5th, Jerry Butts and you got together, and you've told us that he speaks with the full authority of the Prime Minister. On December the 18th, your Chief of Staff had a meeting with Mr. Butts and Ms. Telford. So isn't that at the very least a misleading statement by the Prime Minister? You did speak with him. Your people spoke with him. You spoke with his people. Isn't it, in fact, misleading to say you did not do that?
Well, again, I'm not going to speak directly to comments that the Prime Minister made. I believe that the chronology and the facts that I presented here before the committee and the testimony that I've given speaks for itself.
Okay. I'd like your comments on something that was referred to earlier. In your testimony, you said on December the 19th, you had a call with the clerk of the Privy Council office, Mr. Wernick, who testified here before. And referring to the Prime Minister, the clerk said this, quote, your words, "He's going to find a way to get it done one way or the other. So he is in that kind of mood, and I wanted you to be aware of that." What do you understand by those comments?
Well, as I said, I had, during this conversation with the clerk, I had a heightened level of anxiety. Again, this was the culmination of many meetings and telephone calls with either myself or my Chief of Staff that continued to escalate. This was the top of that escalation. And I said there were 3 times in this conversation where I felt that the clerk invoking the Prime Minister's name was acting in a threatening manner.
Mm-hmm. Do I have another? All right. You've told us, and the Order in Council precludes us from talking about things after January 14th. Apparently that's the rules. We can't talk about that. But on February the 18th, Jerry Butts, the senior advisor to the Prime Minister, resigned. We had all these meetings about SNC-Lavalin. In his letter of resignation, he referred specifically to you. Do you know why?
I have absolutely no knowledge other than what everybody has read in the statement by Jerry Butts, why he resigned, if there was any other reason.
Thank you.
Thank you very much, Mr. Rankin. That concludes the second round. We now have already agreed that we're going to do a third round. So just for Ms. May had mentioned this to me, and I saw Mr. Fortin putting up his hand. What the committee has done in the past is in the very last round of questions, when we realized we were in our last round, we've asked for consent for the Bloc Québécois that was here to ask a question. When we get to what the committee agrees is its last round of questions, I will ask the committee members at the end if they agree to that, and that's where we'll go. But we won't do it each and every round.